You see, there's something I want to say to all of us here. We're here to do justice to all parties. And lawyers are ministers in the temple of justice. We must try as much as we can to speak out the truth in the furtherance of administration of justice. We must never hide under the issue of technicality to derail or to curtail or to destroy the substance of what we are here to administer. Leonard CNN, you are a well-respectable member of the legal profession. And of course, certainly, we always, and others will always be looking up to you to exhibit the best in you in terms of administration of justice in the country. We must bear in mind that it has been tested several times that the quorum of this tribunal can be duly constituted by a chairman. The most important thing is that the chairman must be present in all the sittings of the tribunal. If it were to be all the other two members or a member of the tribunal is adjudicate, that is when an issue of improperly composition can be raised. But whereas when the chairman is present and a member, it supposes that the quorum of the tribunal is duly constituted. It's duly, we have tested that several times.
Is that your lordship's, your honor's ruling? Because we have also tested it even when the Court of Appeal sat with less than 3 members.
Yes.
What it says is that for the tribunal to assume jurisdiction
yes.
at all times,
yes.
The tribunal must sit with chairman and 2 members. I'm saying so, sir, with respect, and I have done quite a few matters up to the apex court in this country.
Yes.
The point remains that when these issues arise and we have dissenting, conflicting positions,
yes.
only one court can decide that matter. If your honor rules, and you take the position that you are taking, there is another court that can decide the matter.
Yes.
That's my simple point, and it's a constitutional right of appeal. Nobody wants at this point or at any point to use technicalities to thwart the cause of justice. No.
Yes.
Those things that you call technicalities are part of our law.
Yes.
They are put there in the law to safeguard the interest of defenseless people who come before this honorable tribunal. And therefore, when we raise them, we don't raise them because we are scared of appearing or defending ourselves. We raise them because the law says we should do, and we'll be failing in our duties. Because at that point you will say, but why didn't you draw my attention to it? So what we are, with respect, saying, sir, is that we have shown, with profound respect, that processes have been filed in the Court of Appeal. My learned friend knows, and he has argued par contrarium to that position, that you don't need an order of the Court of Appeal when processes are pending. Give the Court of Appeal an opportunity to decide on the matter. They may decide tomorrow, they may decide on Wednesday, they may decide after Salah. But I'm sure this is a matter of serious national importance, and great caution must be taken that we tarry slowly and proceed in such a way as not to give the impression that any of us has an interest otherwise than doing what is in the interest of justice. So I urge you with profound respect to adjourn the proceedings. For howbeit, no matter how short, allow the Court of Appeal to decide, not appeal, but our stay of proceedings, which we will not compromise here. Because the law is, we have authorities here to show that once processes are pending and it is drawn to the attention of this tribunal, all of us should wait. And let the Court of Appeal exercise its jurisdiction. Life is still there. Even if I'm not here today or any of us is not here today, there will be people to come and take up this matter. So I urge us to do what is best in the interest of justice.
But I want to avert your mind to the fact that We have tested so many cases like that. In the case of Federal Republic of Nigeria versus Ilochi or Capo, we had a similar situation whereby they raised the issue of improper constitution of the tribunal, and it was ruled that the tribunal can be duly constituted by a chairman and a member. So many decided cases on that. In the case of Federal Republic of Nigeria versus Niru Badu, that same argument was canvassed. At that time, there was only a chairman and a member, and it was ruled in favor of the tribunal that the tribunal has jurisdiction to entertain an action merely with the presence of a chairman and a member. It has been done.
Nothing stops us with respect from canvassing it today.
Learned counsel. Learned senior advocate, please address this tribunal with respect to what you've just said, particularly sections 305 and 306 of the Administration of Criminal Justice Act 2015.
My answer is simple, that this tribunal is not exercising a criminal jurisdiction, and there are authorities to that effect. And if I take you through the process, that the Administration of Criminal Justice Act does not apply to this tribunal. It applies to courts exercising criminal jurisdiction. Your law, which is the Code of Conduct Tribunal Act, and particularly the rules, say you have sought specifically where there is a lacuna to the Criminal Procedure Act and the Criminal Procedure Code.
Yes.
In respect of this tribunal,
In respect of trial before the
yes,
tribunal.
this law has not been amended. It hasn't been repealed. It is still operational. As far as this tribunal is concerned, its recourse is to the CPA and the CPC. If the National Assembly had intended that you should be beneficiaries under the Administration of Criminal Justice Act, it should have said so.
It is so that the Criminal Administration Justice Act of 2005 is of general application.
No. Sorry, sir. It is not with respect of general application. They say the law is, or the maxim is, generalia specialibus non derogant. There is a special law in respect of the Code of Conduct Tribunal, and that is the Act. They've made the ACJA in respect of the Federal High Court, the Magistrate Court, the High Court of the FCT. You cannot leave your own law and go to a general legislation and seek refuge under it. To that extent, the Administration of Criminal Justice Act has no relevance or application to this tribunal. And it will be a matter for the Supreme Court to decide when the time comes.
Yes.
My Lord, my first reaction is that by paragraph 17 of third schedule to the rule of this court, your Lordship is enjoined to apply the provisions of Criminal Procedure Act or Criminal Procedure Code.
Yes, as the case of...
Yes, my Lord. My Lord, by the Administration of Criminal Justice Act,
Yes.
those laws have been repealed by the Administration of the Criminal Procedure Code and Criminal Procedure Act. So, my Lord, but more relevant to our case, my Lord, is Section 1 of the Administration of Criminal Justice, Section 2, my Lord.
Yes.
Section 2 of the new Administration of Criminal Justice Law. So, without prejudice to Section 86 of this Act, the provision of this Act shall apply to criminal trial for offences established by Act of National Assembly or other offences punishable in the Federal Capital Territory. Yes. So, my Lord, the Code of Conduct Tribunal Act provided for the offenses that we charge. Those offenses are on the face of the charge. Is the Act of National Assembly that incorporated those offenses that are prescribed by the Constitution. Yes. So, my Lord, this make it clearly applicable to your Lordship. Yes. So, my Lord, it is not true that the National Assembly do not intend that the administration of criminal justice law will not apply to Code of Conduct Tribunal. That is not the intent of the National Assembly. They stated their intention clearly. So, my Lord, that interpretation is also wrong. So, my Lord, by that, my Lord, the provision which your Lordships refer, my Lord, and subsection 2 of section 2, the only code that was excluded from the operation of this law is the provision of this act shall not apply to court martial. It's only court martial. Yeah. So, my Lord, they don't have the monopoly of this knowledge. We also have it. We also have the knowledge.
As I said,
so, my Lord, by the provision of Administration of Criminal Justice Law, your Lordship should not stay. That's the intent of the act. Yes. Whether made orally or in writing. Yes. Whether made orally or in writing, the proceedings must not be stayed. Yes. Because we have suffered a lot. Yes. We want to address our problem as a nation. And that is why this law was made. Yes. And what's our problem? Corruption is much. Yes. We need to tackle it. Yes. And that is why we said you cannot sit down in your chambers and prepare and you go and smuggle a papers. Yes. At the Court of Appeal and say, no, you can't go on with the criminal trial. Yes. The law says, don't stay. The law says, don't stay.